The decision to remove a sitting Chief Justice has divided opinions. And depending on where people stand, they are for or against this very decision by this government. But beyond the removal of Gertrude Torkornoo is also the need for a country to look at how to deliver better justice to its people and how to ensure that the justice system works. That's what we want to talk about tonight. Hello, good evening, and welcome to Agenda. My name is Beatrice Adu, and like I just told you, tonight we are going to look into the way forward, how to ensure that the right measures are put in place to prevent a recurrence of what happened to Gertrude Torkornoo, which many people feel that might be good or bad for the current judicial system. I'm joined in the studio now by Sadat Haruna Al-Hassan. He's lawyer and member of the NDC legal team. Good evening to you, sir. Thank you very much for joining us.
Good evening, madam.
I'm also joined via video call by Professor Enoch Entry. He's a governance expert. Good evening to you, Prof. Thank you as well for joining us.
Good evening, Beatrice, and greetings to your viewers everywhere in the world.
And of course, we're joined via via phone as well by Gloria Oforibuedu. She's lawyer and managing partner at GOB Law Consult. Good evening to you, ma'am. If you can hear us, she'll be joining us very shortly. Professor Enoch Entry, if you're able to adjust your video for us, landscape, so we are able to see you better. Like I just told you, there have been a lot of opinions expressed on this very decision to remove the Chief Justice Gertrude Isaba Torkornoo. One of the people who has spoken strongly about this as well is a former Supreme Court judge, Justice William Atuguba, a man who also once, actually twice, acted as Chief Justice during the reign of the former CJ, her ladyship Theodora Georgina Wood. I want you to watch this and to hear exactly his perspective on what has happened so far. Watch this.
In the first place, these procedures were supposed to be in camera, so ask me whether I've followed or I could have followed, except they leaked out by chance. They were supposed to be in camera, you know. But what came out in the public domain satisfied the constitutional requirements. Petition is received by the president. If it's not frivolous and vexatious, because Ajechum and Attorney General said it, if the petition is patently frivolous, the president needn't even forward it. But if it is not, then he consults the Council of State. And they find that is Ajechum introduced prima facie also in relation to it. If it is found, then a committee is set up in accordance with the provisions. The committee goes in, they hear the matter fairly and thoroughly. And then the recommendations, well, I think that was done.
So the process was fair?
Oh, yes, I know.
But this Miss CJ doesn't think so.
Do you expect her to think so?
She during a press conference, complained about being denied the presence of her family, searches and what she called mental torture, even in a supplementary affidavit. I'll just read a bit of that to you. She said, a complete desecration of my basic constitutional right to a fair trial, violation of my dignity and subjection to inhuman and degrading treatment, a kind not meted out even to accused persons on trial for treason and other offenses against the state. She went on at that press conference to talk about the Edu Lodge, which was used as a place of hearings and a reminder of how her uncle was murdered, as if to cower her into intimidation and all of that.
But I saw on social media a video when I think that place was refurbished very heavily, and the then president praised its quality and everything. So I don't know. Now I say that if in a certain court, let's say it was being tried, or this investigation was in open court, and a member of the family shouldn't be used. I don't know. I really don't know.
So you disagree with her description of the process?
Oh, sure. I mean, these things are neither here nor there. In the long run, it is the substance of the matter that matters. The substance of the matter. Was she given a fair hearing?
She said she wasn't.
Oh, what? I don't know. This was in camera. How did she say she was not given a fair hearing? Because of what I said, bodily searches, and her family shouldn't be there. If the thing is to be, the Constitution says 146(5) plus 5. All proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other expert of his choice. So if it's in camera, has a provision for, allowing your relatives in? Why is that provision?
So she didn't have any cause to complain?
I mean, unless she has a different understanding of what in-camera proceedings mean.
There are those who feel that Article 146 in itself perhaps has an issue and needs to be looked at. And those people who share such opinion include the former CJ as well, Sofa Akufu, who even cited the Ajechum case as an example and felt that this whole process that we've taken the current CJ or the dismissed CJ through was very unnecessary, and Article 146 is the problem.
Well, I haven't seen reasons, the grounds for particularizing the imperfection or the the defects of Article 146. There are no grounds. Now, but the interesting thing is, if you look at 146, it's even better than the appointing process. The appointing process is even more political than the removal process. More political. In the case of the Chief Justice, you are nominated by the President, then in consultation with the Council of State, and approval by Parliament. Judicial Council is out of the way. And are we saying that that is a non-political process of appointment? So if you accept that as good enough, the removal process, even you must have 2 Supreme Court judges.
Yes, it's in there.
Yes, in there, which is a check on, the process. But as for so you have judicial control there. But as for the appointment process, it's all political. And so that one is sweet to take. But this one, which even has 2 Supreme Court judges on it, is entirely political. I can't reason like that.
If you were advising her, what would you tell her?
Yeah, she should, if she feels that she has concrete grounds as a lawyer vis-a-vis the grounds for removal, that is fine. But if it is just, an emotive exercise or a fishing exercise, let me try my luck, I must survive, I can't. The posture is that this position is mine, and nobody can take it from me. That's the posture I get. It's not very healthy. Maybe if I were to read the proceedings, if they were available and looked at complaints and they were tangible, okay, fair enough. But the posture is like somebody is trying all means to cling on to the position.
So what do you foresee? That's my final question.
What do I foresee?
Yes.
In terms of
In terms of the process, so I'm asking you two questions in one. In terms of the process, the CJ has decided to embark on. Her lawyers telling us that she's going to contest this case in court, and the implications this very case has had on our democracy and constitution, or even the image of the judiciary.
Yes, well, I've got to be careful because contempt of court is a very wide principle. Even if it includes things said that can prejudice proceedings, once you know that court proceedings are contemplated, not necessarily even initiated. It's as wide as that. But what I will say is that from what I have seen, the process seems to be complied with. And unless there's evidence to show serious breaches of it, I don't see how this decision is contrary to the Constitution, because honestly speaking, the provision for removal was not put there to be idle. And in fact, if conditions arise requiring removal and it is not done, it's contrary to the Constitution. Well, the Constitution does not only provide for appointment, it also provides for removal. These two go together.
So and I just watched that interview I had with the former Justice of the Supreme Court, Justice William Atuguba, and I'm coming to my panel now. I did tell you that I have Mr. Al-Hassan with who is a lawyer and a member of the NDC's legal team in studio with us. Gloria Foribwedu has joined us via video call. We'll get into her very quickly. But let me find out from you, Mr. Al-Hassan. This is the first time that Ghana has removed a sitting CJ under the Fourth Republic. And of course, like I just said earlier, there have been divided opinions on it. What kind of measures do we need in replacing her so we don't see a recurrence of this, the removal of another CJ?
Yeah, thank you so much. Let me use the opportunity to thank, I just returned from my constituency, to thank the very good people of Tamale Central constituency, particularly the executives or the delegates, the regional constituency and the branch level, and to also say a very brief prayer for the departed soul, my own lovely brother and friend, the late Honorable Mutala. May Allah be pleased with his soul. Now, on the question of what measures ought to be placed or put in place to get a replacement for the removed Chief Justice, first and foremost, you cannot have any replacement without recourse to law. An appointment of a Chief Justice to the high office of a Chief Justice is a matter of law, just as the law has played out to have her removed. And so it is the law that must be applied to get a replacement for the Chief Justice. And of course, the Constitution has provided for the same. Now, we must recognize that I know there have been a number of concerns in respect of even Article 146 and even 142, which deal with the removal and appointment respectively. But until the right legislative measures are put in place to get it done the way we want it, we can only be complaining and cannot do anything beyond that. Because whatever it is that we want to do, whether appointment or removal, it is the law that must prevail. And the fundamental law of the land is the Constitution. And so, by and large, once a CJ has been removed, there must be a replacement of a substantive one. Luckily enough, at the time she was on suspension, there was an acting CJ. And so, in the wisdom of the Constitution, there is no anticipation that a vacuum ought to be created. And so, once there's an acting CJ, it will only be appropriate to look at the qualities that ought to be considered in getting the CJ appointed. Now, mind you, the current acting CJ is acting on the basis of the fact that the law has provided for the fact that an acting Chief Justice, in his case, only assumes the office in the case of a suspension or when the CJ is unable to perform the functions of a CJ. And so by the constitutional arrangement, the senior most judge of the Supreme Court will act as the Chief Justice.
I want to get your thoughts, Madam Gloria Ofori-Boadu, and I'm sure you do understand why, in addition to what Mr. Al-Hassan is saying, and of course what Article 128 already says about the kind of qualities that are needed. And I'll just read that very briefly to you, because the clause 4 says a person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is of not less than 15 years standing as a lawyer. So that's what has been spelled out. But in terms of qualities, in order to prevent a recurrence of what we saw, what measures do we need to put in place? Madam Gloria Ofori-Boadu, I'm kind of thinking you are muted. If you can unmute yourself so we can hear you. Okay, I'll have to get to Professor Enoch Entry whilst Madam Gloria Ofori-Boadu tries to fix her Zoom. Prof, the same question to you. What are your thoughts?
Can you ask the question again, Beatrice?
Yes, I was asking that aside from what Article 128, Clause 4 says about high moral standard for a person expected to be appointed to the Supreme Court, what else do you expect in terms of measures needed to put in place in getting the new CJ to prevent a recurrence of what we've seen with Gertrude Torkornoo?
Well, thank you. I think that opinions are divided about this, and it depends on where you stand, because psychologically, you even watch a team performance based on the team that you support. So you don't care much about the other team, but it is the team that you support. So if you look at the divided opinions about this, I think that when we talk about high moral integrity, it is something that trait somebody has acquired over a period. And it does not necessarily mean that when that person gets a position, the person will continue to behave the same way. Because there's a popular saying that you give somebody power or give them money and then their behavior changes. So somebody can have that kind of high moral integrity and character, but when they get a position, they can behave otherwise. That is why references are good based on your previous performances. When people get new positions, we have to still have procedures and laws that guide their behavior. So having said that, I don't know why we have been going back and forth. This issue has been, we've talked about this for almost 2-3 months now. And I remember in a letter to his brother, Napoleon Bonaparte wrote a letter to his brother in 1806. And this is what he wrote: more energy, more energy, more energy. And what it meant is that energy was needed. So Albert Einstein said that energy is equal to mc2, which is mass times the speed of light squared. We seem to be spending a lot of our energy on this issue.
No, I'm not muted. I'm not.
We seem to be spending a lot of time on this issue. And I think that we need to spend a lot of energy on other equally important issues. Because the Constitution is clear. We talk about the spirit and the letter of the Constitution. I've also talked about the energy of the Constitution and then the speed of which we handle issues. Now, when we go to Article 146, it's very simple, that the Chief Justice of Superior Court shall not be removed from office, shall not be removed from office, except, so two things are stated. That is, the first one is stated misbehavior, and the second one is incompetence. So the question we should all be asking ourselves is that, did she err on those faults, stated misbehavior and incompetence? Now the others is a procedure, which is 146(2), is the procedure that if the person is caught for stated misbehavior or incompetence, what should we do? It follows that the president will receive a petition. And after the petition is received, he will discuss with the Council of State. That has been done. Now, after deciding that with the Council of States, there are 3 justices that are picked because we are looking for one thing. Prima facie, is there anything that proves that indeed she or he misbehaved, or there was a stated misbehavior. And then we have a committee set up. All these processes have been followed. So why are we arguing about the same issue? I have always stated that power actually belongs to we, the people. So Nixon was impeached. Our president can be impeached. If you go to Parliament, the Speaker can be removed. The same way as the Chief Justice can also be removed. So the three arms of government, even though they are separated, they can all be removed based on the constitutional provision. Now, if all the process of the Constitution have been followed, then why are we still talking about the issue? Why is it a big issue?
So the question I asked you was, in replacing the CJ, what kind of measures do we need to ensure that whatever it is that we have witnessed, we don't see a recurrence? Briefly, and I'll go to Madam Gloria for
like I said, you cannot predict anybody's behavior with substantial accuracy, that when you give them a position, they are going to behave the same. So if you want to avoid such things happening, that means that anybody appointed to that position should make sure that they don't breach any of the clauses of Article 146, period. Now, after that, the woman stated a couple of issues that, she needed the family to be there. So luckily, we have a constitutional review committee that is looking at some of these issues. And I think that it will be fair so that if I am facing that kind of trial, I can have some family members around just to hold my hand and then strengthen my hands. Those can be done. But if we want to change all the provisions of the Constitution because one person has been removed, that means that when we are removing the president or the president is being impeached by Parliament, then we also have to change some parts so that it will suit the person who is coming next. Laws don't change like that unless there's an amendment process that we have to go through. So what I'm saying is that anybody given a higher position, you have to go by the tenets, rules and regulations of that position. If you breach them, that is why once you are appointed, the previous caller made it clear, and I agree with him. Once there's an appointment, there's also an avenue or procedure for removal. So if the procedure for removal has been followed and nothing has been breached, I don't think we should waste a lot of energy talking about the same thing, because we are a country that have a lot of issues that we should be talking about, not that somebody has been removed. Even though I understand that we have to watch our Constitution the way it gives a lot of power to the executive. We have to make sure that the legislature and then the judiciary have equal power so that the checks and balances will happen as we all anticipate in our Constitution.
Let me get your thoughts, Madam Gloria Foiwedu, first of all, on what Justice Atuguba told us earlier. And of course...
You know what? I think I've said everything there should be. I mean, everything I need to say. I've written everything I need to write. I just simply think that as of now, our Constitution, those who are working on our Constitution should find a way of of dealing with this winner takes all syndrome. It's really creating problems in our country and in our country's governance. And if we don't put a stop to that, phenomenon, one day there's going to be crisis. And when I talk of crisis, it's going to be very serious crisis. Why don't we study from the Scandinavian countries, or even from UK, which, gave us this kind of pattern, democratic pattern of a kind of winner takes all. Why don't we study what they've done in terms of coalitions, in terms of having different political parties in their governments, so that it won't be just one-sided. One party wins 5 million votes and suddenly takes over every, apparatus of government, from the top right down to the messenger or the driver, right down to the chief executive, right down to the minister, deputy. It's getting sickening. And because of that, there's so much hypocrisy in the system. So much hypocrisy. Look, what I thought was that this committee that was put in place, because there had been an allegation or some perception of compromise on some of the committee members, the president will have accepted the petition of the young man, Kumi, who came up with this, alert that, please, there's been this contact between some members of the committee and a lawyer for one of the one of the applicants. So please, look at it, let them step aside, take your time, find out what is going on as a father of the nation, talk to the parties, let them come out, because I'm even told that the chairman was even not there and has been kind of wrongfully accused and all that. Let's go into it and get them exonerated or get the perception of bias and compromise, eliminated or alleviated before you continue with the sitting. But no, it wasn't like that. Everything has been rushed. And now they are touting that they removed the CJ. You have removed what CJ? On what grounds? On what grounds and with what committee? A compromise committee or a perceived please, we are not jokers. We have a country. Please. I'm just appealing that we have a country and we have a future for our future generations. Some of us are older. We've done what we have to do. I'm even on retirement, I must say. But I'm just thinking, why this hypocrisy? Why this compromise? Is it because one party wants to keep all the, the governance or the arms of government in their, embrace, have the judiciary controlled, have the parliament controlled, have the executive controlled? Please, it's not right. Let's look at our constitution again. Let's even learn from the UK. Let's learn from different countries who gave us a form of pattern that we are trying to follow. Our political scientists, please be up and doing. Give us a working constitution so that we don't have this danger of winner takes all, which for years, eminent persons like Mr. Emil Short, some of religious bodies, some religious leaders have been speaking against it. And I'm telling you and I'm warning you that if we continue the way we are, maybe one day, touch wood, when some of us are not here, something will happen. And I don't want to use the word of what will happen, but we are in dangerous times.
We are in dangerous times, you say, and of course you express the view about the need for us to look at our constitution again.
We really have to, because all that is going on is just a desire by, one, one party to have everything. And I'm saying that irrespective of which party comes into government, there must be power sharing. It happens even in South Africa. It happens in the Scandinavia country. They have ambassadors here. They have embassies here. They have high commissioners here. Let's learn from them and come up with a workable template that will put a stop to this winner takes all.
I want us to take it one by one, and I'll come back to my guest in studio.
I don't think I want to talk much. It's late.
I do understand that.
I've had a very busy day, my dear.
And you did say that you have already expressed your view about the CJ thing. Yes, but I'm surprised.
I've been insulted. Even the last time I got an insult from one of them that my wig is so terrible, and I just laughed. I said, well, wigs can always be changed, but please, we can't descend into the gutters. What I'm telling you, someone called me from South Korea and said, have you seen that you have been insulted with your wig? I said, so you are seeing it in South Korea? And the person said, yes, please.
Okay, I just
honestly,
want
to... I think I'm tired. I make my point. Can I be excused?
I will have to come back to you, Madam Gloria Foribuadu. Yes, because the point I wanted to ask you was that I know you talk about the fact that you've made your point already, but I'm just surprised you're saying on which grounds when the committee said that, the committee made it clear that it is based on stated misbehavior. So I just wanted to make that clear to you before we move on with the conversation. But again, the other question I was also asking you was how to ensure that we get the person who is fit for the position. I'm sure you're aware, if you would allow me, ma'am, if you would allow me, and I'll let you go
because I've made my point. I've said that the Chief Justice removal, there's a form of flaw. I'm not being personal, I have nothing against anybody. But I'm just saying that even if we are going strictly according to the Constitution, there's a petition before the President submitted on the 19th of May by someone who saw something, a perceived compromise of some of the committee members who have to come clean, because I believe that it wasn't all of them who were there, but at least something has to be done. I'll keep repeating. I don't want to repeat it. So I'm not being personal. I'm just saying that. So can I go now?
Let me ask you this before you go.
There's a flaw, and it can be challenged in future. There's a flaw in that so-called constitutional removal. It borders on violation of due process, constitutionalism and the rule of law. And it will be picked up. We are lawyers, and the law is the law. You know, let everything be clear. Committee should be clear, and then whatever procedure should be clear. That's all.
Let me ask you this before you go.
Can I go, my darling?
Let me ask you this before you go, Madam Gloria Foribwedu. In terms of the lessons that you believe the incoming Chief Justice must learn with what has transpired so far before you go.
Jurisdictions and see how we'll not have winner takes all. Otherwise, it's going to spell some doom and crisis for this nation. Even those who left us that template have moved on. Why can't we move on?
Madam, you haven't answered the question. Just briefly before you go.
Dear.
I'm just asking you in terms of lessons for the incoming CJ and ensuring that we're able to get a person fit for purpose. And I was explaining that.
What do we mean by? You see, I don't want to talk too much. What do we mean by a person fit for purpose? I'm telling you that the whole removal process is flawed, and I've given you the reason. Why do you want me to move to another? We haven't even finished. You know, the removal is a flaw. Why do you want me to talk about a person fit for purpose? That's a flaw in the removal.
Is there anything the incoming CJ must take notice of in terms of lessons?
My dear, I have answered your question at the base. I can't move to the, what do you call it? I've told you there's a problem with the removal. Why do you want me to talk about anything else?
Thank you very much, Madam Gloria.
Why?
Okay. Thank you very much. I want us to get, again, a quick thought of Professor Inokentri. Just what you think of this submission made by Madam Gloria Foribwedu, and then I'll come to Ms. Al-Hassan in studio.
Yeah, Beatrice, my final words here is that from the
Not
way
your
the
final
woman...
words, though, just on what Madam Gloria Foribwedu has said. Yes.
What she's saying that she's trying to avoid some questions because there seems to be a danger of people speaking, and that is dangerous to me. People have the fundamental right to express their opinion, you know, even freedom of expression. You can just wink your eye or do anything. The Constitution allows that. So those who like to insult and threat people when they speak their opinion, we should stop that. There will be a time that nobody will want to speak on national issues because of insults like this. I remember Angela Merkel, when she was the Chancellor of Germany, somebody raised the same issue that she's been repeating her dresses, and she said, I'm not a model. So personal attacks should be out of our conversation here. We are all here spending nights and coming to studios to educate our people because we need that kind of education to help us move forward. Having said that, I think that we all agree that the Constitution is flawed in many ways. If you look at Article 148, it said that the judicial power is vested, the office shall be vested subject to approval of the president. Why don't we change that and make the Judicial Council, you know, appoint their own Chief Justice instead of the president coming in? So the onus now rests on the constitutional review. But unfortunately, people who are talking about flawed constitution, we have President Kufuor, who is a lawyer. We have Anado, who is a lawyer. None of them touched this. President Mills started this, and then it did not end, and now President Mahama is continuing with this constitutional review. The lawyers did not touch this. They thought it was okay. Now, all of a sudden, somebody has used the process to remove somebody legally, and then we are talking about flawed constitution. What did they do when it was their time? 8 years, another 8 years, 16 years. So we need to educate ourselves. It doesn't matter of the party that you belong to. Those who went through the process, the Constitution says that pick 2 Supreme Court judges, pick 3 another people, which is 5, and the remaining 3 should not come from the judicial service. They should not even be lawyers or members of parliament. They should be ordinary people. And all these processes, the current administration followed them. So when somebody comes and talk about, you know, coalition government, yes, we need coalition government. A winner takes one, nobody likes it. Because when the party lose power, even the public toilet in our villages, people go and kick others out. Why are we doing this to ourselves? So the Constitution, if it is flawed, as she's saying that the basic fundamentals of the Constitution is flawed, then let's go back. Unfortunately, this president have done the right thing by appointing a constitutional review team. And Professor Prempeh and his people are supposed to be neutral. People have submitted their petitions to them that, hey, these are the things we want you to look at. Let's all focus on that, because this is also an opportunity for us as a country to learn and then change some tenets of our Constitution so that when a decision is made, everybody will be happy with it.
Everybody will be happy with it. I want to ask you the same question, Mr. Al-Hassan, about what lessons the incoming CJ needs to learn. Of course, admitting the fact that there is a need to look at our constitution in the current state as it is?
Thank you. Do I have the benefit of also responding to some of the issues raised by Madam Gloria? First and foremost, we must recognize that our contribution to the discourse is to educate the public, to set the facts right. Now, when you say there's a need to have a union or coalition government, I don't know at what point that idea was conceived, but in 2017-2020, Madame Gloria was in this country. Nana Addo was the president, and I have no doubt that at the time she had this idea. She never proposed this to the government.
How do you know she didn't?
I know her. I know she had ideas at the time, and I'm convinced that she had this as part of her ideas at the time.
Yes, but you're saying that she didn't. How do you know that she didn't propose it to the president?
The same medium could have been used. You don't need to use private sources. This is the medium she's using today. She could have used the same medium at the time. Radio stations and all that. Make your views public. So that's the first thing to deal with. So it's not as if it's alien to our democracy. It has always been the case. And you cannot all of a sudden start arguing that there's the need to have a union government. Everybody wants that, but until you have demonstrated that the party that you also align with, you are giving them those suggestions and they rejected. That's when you can be arguing.
Well, hopefully she has the opportunity to respond to that because she cannot conclude that she didn't do that.
Very well. That's why I'm saying that I need to respond to that. Now, the other thing has to do with the issue of whether some committee members met some other lawyers who were against the CJ and all that. I think these matters came up and we dealt with them extensively. The person at the center of the issue came out publicly and denied this. And the matter was dead, long concluded and dead. So I don't know where this is coming from. You see, we must move away from emotional arguments to factual matters. The other thing relating to the removal being flawed, where she says who has been removed or who has removed her, as if you are not recognizing the removal process. That in itself might even amount to an offense.
No, but she's made it clear that she thinks that the whole process was flawed.
No, and I'm saying that her initial remark was that who has removed her?
But that's her opinion.
No, but you cannot say that. The person has been removed in accordance with law.
She's entitled to her opinion just like you are.
I have no problem with that, but I'm saying that I'm speaking to law. The thing is that the person has been removed in accordance with law. And that is the law now. You cannot be saying who has removed her or she has not been removed.
So now the question I asked earlier about whether or not there's any need for lessons to be learned from, by the incoming CJ.
Yeah, the lessons have been learned largely by the incoming or whoever were appointed. In fact, the current crop of Supreme Court justices have learned huge lessons from the conduct of the removed Chief Justice. It means that, you see, when the Constitution speaks about certain qualities of a judge in terms of proving character, high moral character, and proving integrity, they are not just beautiful words being used in the Constitution. They have meanings, and those meanings ought to be interpreted properly. Moral character, you must demonstrate a certain degree of morality. And you know what morality is? Your ability to distinguish between what is right from wrong. Those are the things you should be very minded about. Now, you are also talking about proving integrity. You must exhibit a certain level of honesty, sincerity, and candor in your conduct. Those are the indicators. And so they are not just captured in the Constitution just to make the Constitution sound so lovely or beautiful. But we must leave those words. If you don't leave those words, the natural will catch up with you in the nature of such petitions. Remember, for somebody to argue that the removal is flawed, you should be pointing to the specific provision that has been breached. Because the committee that was constituted on the basis of Article 146. And Article 146 specifically which deals with the removal of the CJ. When you come to Clause 6, once the committee is constituted, it is expected to exercise some level of fairness, some level of due diligence, some level of accountability, even in dealing with the person at the center of the whole issue. Wasn't that the case? When the article says 146(5) says it should be in camera, you cannot be going there with everybody. In camera means in camera. We are lawyers. We should know better. So I was surprised the CJ brought the matter up complaining that a family member hadn't been allowed in camera means in
So
camera.
the point you're making with the question I asked earlier is that based on what I read earlier,
Yes.
Article 128,
Yes.
Clause 4, that is what the incoming CJ should be expected of, and the
Exactly.
kind of lessons that
Yes.
we learned. I want to come to you, Professor Enoch Entry. People argue that with this precedent set, perhaps we should all expect that the next CJ could be equally removed if by 2028 the next government is a different party other than the NDC. How do you reason with that?
Well, I've seen that going on a lot in social media, and even some ladies saying that the women should stand up because this is injustice against women. All of these are just sentiments. And Beatrice, if you go to the courtroom and you see people who plead and lay on the floor and cry for forgiveness, but they say that the law is the law and nothing is done about it. Go to the courtroom and you see people who have stolen little things and they are sentenced 20 years, 10 years. They cry, they beg. Nobody listens to them. So I was a little bit surprised that a Chief Justice who have supervised the same judicial system, now she's facing the same system she's complaining about, not facing fairness and all that. So people who say a lot of things, what I will expect moving forward is that we should make our constitution, the review, in such a way that it will be difficult to remove the Chief Justice. But it shouldn't be that it is blocked, that you cannot remove the person, because we should have provisions where when the person breaches those rules and regulations or moral conduct, then they should be able to be removed. The other thing, is that moving forward, we need any person, some people are even on anxiety pills. What it means is that they are very anxious when people are around and they are speaking. So we should allow families to join them when they are going through these processes. And then I'm also saying that it should not be in camera. In camera means it's in private. Nobody sees what is going on there. And some people want it to be public, but it's not always everybody who also wants their issues to be public. Some people will want the private case to go and then argue their case privately. So we should not be looking at the sentiments alone. We should be looking at the logic behind whatever we are doing. Other than that, we'll be swayed by different opinions, and then the law will not work as we all expect it to work.
Do I hear you say that, irrespective of what has happened and the comments of people that because of this precedent, there could be that repeated removal of CJs, you don't foresee that?
It could happen because the president can be impeached. The speaker can be removed. The Chief Justice should be able to be removed because power do not belong to any of the three arms of government. Power belongs to we, the people. So if you are going for public position, don't think it is yours. You are just a steward. You are holding the position in trust. And one day it will be taken away from you based on the stated things that when you do, contrary to your position, it will be taken away from you. And one or two of those things is stated misbehavior, misconduct. Even if mentally you are not capable, of course, we should be able to remove you.
Let me ask you this before I come to Ms. Al-Hassan in studio. I'm sure you're aware that if you followed the process, the removed CJ talked about or expressed her misgivings about the acting CJ sitting on certain cases that were brought before the committee and other staff. What kind of perception do you think the confirmation of Justice Bafuboni, for instance, gave the current administration?
You see, the challenge with the behavior, and these are all stated misbehaviors, the challenge with the behavior of Justice Tukunu is that she began accusing fellow justices of the Supreme Court that they will not be fair to her. So the question I asked myself was, does she have any problem with any of them thinking that they will not be fair with her? Of course, if there was such a problem, then she could have requested that they change the person sitting on it. But the Constitution does not make that provision. You see, I've been talking about what have we learned from every situation that we find ourselves. If we don't learn, life is such a way that it will keep pushing us down until we pick something from that floor. So if I belong to the Supreme Court, and then previously Tokono was the boss of Bafuboni, and now somebody is acting in your position, and then a committee has been set, 2 from your own colleagues, 3 from outside to look into the issue. She started picking some individuals from the committee that this person will not be fair to me, that person will not be fair to me. But it is not your call. You go to court and then there's a judge sitting on your case. You say that I don't want this judge because this judge will not be fair to me. So she really led a justice system that she doesn't trust. And for me, that's a fundamental problem. You flip the coin. Now the same system that you've been leading is judging your issue, and then you think they're not going to be fair with you. Is it fair for all of us to say that then when we go to court in Ghana, the judges have not been fair to everybody that have been sentenced or that have been removed from office?
An interesting question there, Mr. Al-Hassan. What do you make? We've heard the argument of Professor Enoch Enchi there. From where you sit, before we even think of looking at the law as it is now, do you foresee this repeating itself?
Well, I mean, like I said, there will always be repetition to the extent that people will not act in accordance with the dictates of the Constitution. And the classical case of such thing is what we are seeing now. A number of people have raised concerns about how Justice Tokono treated them, to the extent that even senior lawyers, seasoned lawyers, that I can mention their names, have had cause to complain about the way he treated people. And you see, justice system is such that if you don't demonstrate some level of objectivity, impartiality, and independence yourself, you are giving reason for people to doubt you. And because he was the head of the judiciary, anything that he did was a reflection of the system itself. And therefore, for people to have said that they didn't trust the system simply meant that he was the one they didn't trust. And you see it reflecting in the petition. The petition, if you look at the Daniel Fori's petition in particular, the petition has catalogued a number of issues, ranging from the days she was even a high court judge, through Court of Appeal, to the Supreme Court. And so it tells you that it didn't even just start now, but it started long. And that because she was in a position where she was highly protected, she was covered. Remember, the petition against her removal didn't just come under this regime. Just before the former president, Nana Addo Dankwa Akufo-Addo, left office, a petition came against the same person.
And indeed, this is not the first time that we've seen petitions against Chief Justices.
Exactly.
Although there have been attempts to remove the CJ, like I just said, this is not the first time that this is happening. How do you feel that it is under this current government that we've seen this very Article 146 fully implemented or activated?
Yeah, it simply means that at the time that people were petitioning for the removal of CJ, they're beginning to pick signals and to realize that there was a need to hold people to account, and that the offices people assume are not personal properties, but they are properties that are supposed to be held in trust for and on behalf of the people. And so you don't treat it as though it was a personal property. Now, the several attempts that have been made in time past to remove justices that did not work or succeed simply meant that there were some merits in the case in favor of those Chief Justices. And that's why they didn't succeed. This one, remember, the same CJ on 2 occasions, different petitions. It's not like even the same petition, but different petitions have come against the same person under her own regime and under another regime, the current regime. And when it came under the first regime, interestingly enough, you saw what happened. People are complaining about the need to see what went into the prima facie determination. Nobody saw what went into that determination under the previous regime.
Would you support calls for the committee to make the report public? We've had somebody like Martin Kwegbu, who is a private legal practitioner, for instance, quoting the Supreme Court's own rules, saying that when a committee finishes its work, it can publish the report. So would you support that call, just so there is clarity for everybody to see exactly what might have happened and the reasons they gave beyond the stated misbehavior that we saw?
I think the recommendations of the committee are even public now. They are reading it. There are excerpts, people have them and they are reading them. And so it's good to have it public so that to more or less endanger, to avoid a situation where the trust and the confidence of the people in the system itself is endangered. Let's avoid that. So it's good we make documents public to the extent that the law allows that to happen. Otherwise, we are going to be going around the same table. And like I said, if we had done that under the previous regime, I don't think that would have been an issue. But because under the previous regime, that wasn't done, that is why we see it to be a challenge now. But like I said, even though you see it written, restricted on the document has become a public document. And it's in the media space, people are reading them. Now, on the issue of the outcome or the committee's work being flawed, I mean, the recommendations are there, and we must read it. If you don't read it and you are wondering the grounds, the basis for the removal, stated misbehavior, and everything has been clearly captured in it. And so let's avoid making such statements as though somebody just woke up one day and removed the CJ. No, that wasn't the case.
And I'll be coming to you again, Professor Enoch Entry, very shortly for us to wrap up our conversation. But I want to bring some of your comments back to you. Sedem Woglo says, even if, okay, he says, let me rather read that of Kwame Nateyadi. He says, you cannot do what you want even if it's against the law because you are the CJ. That's the lesson. So I guess you're talking about what lessons the incoming CJ must learn. That question posed earlier. There's James Jordan who says, anybody who believes that the removal of the Chief Justice is flawed should go to court and challenge the decision of the president. I want to read one more to you. Clifford Asameni, he says, Prof, there's no danger. Okay, so kind of responding to the comment by Professor Enoch Entry, following the statement made earlier by Madam Gloria Foribuedu that if we don't deal with the situation or the current situation of the country, there is danger ahead of us. Prof, I'm coming to you. I know you've spoken about the winner takes all points that Madam Gloria Foribuedu made, and also talked about the need to look at certain portions of the Constitution as well. Moving forward, what are other recommendations you have in order to ensure that we're delivering the kind of justice that Ghanaians deserve?
Beatrice, thank you. I think that Gandhi taught us something that is very important, self-respect. And when he brought the non-violent strike, sitting down strike to press for people's demand, I side with him. I think that you cannot have a process that is in camera and then want the report public. Moving forward, we should have this process public so that everybody will know how it started and how it ends. In the same way, some people will be at ease so that they will not be in panic and be touched, as the removed Chief Justice have said. Also, we need to respect the president because he followed a procedure laid down accurately in the Constitution. If we think the Constitution is flawed, then we should change the Constitution, not the president when he acted on the provisions of that Constitution. The other thing is that the removed Chief Justice can return to private life and live a private life. I think this issue has received a lot of airtime and a lot of people's attention. We have a lot of pressing issues as a country that we should move on towards too. It should not be politicized. Unfortunately, everything is politicized. When you talk about winner takes all, like I said, when the new government comes, when NDC left office, there were some people in NDC who were not even allowed to go to the office and pick their file. MPP people are complaining about the same thing. So what it means is that when your party loses, don't even try to go back to work because you'll be removed anyway. That shouldn't be the case, because if you go to anywhere in the world, what happens is that your job is not affected by a change of government. You continue to do your job once you are efficient in doing what you do. And I think moving forward, that is what we should be looking at.
That's what we should be looking at. Let me get your final word, Mr. Al-Hassan. I think one of the points also is that if you want to depoliticize the entire process, then the president shouldn't be appointing the CJ, which would give that kind of subtle, a soft spot, as it were, in listening to the executive. What's your take on that and your final word?
Yes, so on that issue, you know, the president appoints the justices on the backdrop of Article 144. That's the appointing article. Now, you note that the president has no option to act outside the Constitution. And so if it is what we have today, just as he has acted in accordance with the Article 1469, which deals with the recommendations of the committee, the specific provision says that the president, acting in accordance, that he shall act in accordance with the recommendations of the committee. And so if somebody suggests that what the president has done or the removal is flawed, you begin to wonder. Let's be pointing to specific provisions that suggest that flawed position.
Your final
but
words
the point is that if we want to have any changes to the Constitution, we must come together and bring our inputs. I have made a lot of inputs into the Constitutional Review Committee. A number of people, good citizens, have made it. Ordinary people, lawyers, judges, even the presidency itself has made a lot of inputs into it. That's the only way we can move forward. Until that is done, if we are acting according to the dictates of the Constitution, I don't think it is so right, especially for a lawyer to say that something is flawed when you have not even able to establish a single breach.
That's the only way.
Let's not advocate that way. We are lawyers.
That's the only way we can deal with that. Thank you very much, Sadat Haruna Al-Hassan. He's lawyer and member of the NDC legal team. Of course, we also had Madam Gloria Ofori-Boadu, who is lawyer as well and managing partner, GOB Law Consult. She had to leave us a bit earlier. And also to you, Professor Enoch Entry, governance expert. Thank you very much for joining us, gentlemen and lady. My name is Beatrice Adu. Thank you so much for joining us on Agenda tonight. Join us again next week.